and then we have a list of everything that's in their district, who the companies are. We need to explain to politicians and policymakers not just big numbers about jobs and big numbers about economic growth. We need to show people what it means for jobs and economic growth and environmental projects in the places that they care about most, namely their district from where they're getting elected. Getting elected. All right.
Both and.
Both and. This is really a both and. Start off by saying the old saw about you could either have jobs or the environment. Let's get rid of that. That's a dichotomy that never really existed. It's false. It's a myth. We can have job creation, economic growth, and environmental progress together. We've got to do that for climate change solutions that work well for both, the both and, the environment and the economy. And anyone who says you can't do it, that those are somehow irreconcilably in conflict, just needs to look at, a slide that's something like this. Remember, wind power wasn't going to be feasible. How many jobs has that meant for Iowa? How much economic growth has it meant for Iowa? How much CO2 taken out of the atmosphere has it led to? And look what happened in the last election cycle. Governor Romney said, I oppose the production tax credit for wind power. President Obama said he supports it. Everybody remember what Chuck Grassley said the day after Romney said what he said?
Stupid.
Stupid wasn't the term, but close.
Gotta go talk to him?
Governor Branstad said, we disagree with him. We need to go talk to him. That noted progressive environmental Democrat, Chuck Grassley, said that Governor Romney's opposition to the production tax credit for wind power was, quote, like a knife in my back. Another progressive environmentalist, Congressman King, said that Governor Romney was wrong. Congressman Latham said he disagreed with Governor Romney. Politically, this is working for us now. What we need to do is remove some of the barriers the utilities are creating, and Barry will talk about that one. I'm not going to steal his thunder. We need to be aligning the economics with the policy, with technological innovation, and we need to tell everybody, because we can demonstrate the facts on the ground, that there are climate change solutions that work well, both and, for both the economy and the environment, and then we need to work hard and get it done. And we look forward to working with all of you at Iowa Renew to make that happen. Thank you very much.
Well, Howard's a tough act to follow, but I'll give it a shot. I'm really pleased and flattered to be here today. I'm involved in a big issue right now, which I'm going to tell you about. So the reason I'm here, I guess in the words of Captain Kirk, I've done something that no man has done before. I've formally and frontally taken on Alliant Energy, Mid-America Energy, the Iowa Association of Municipal Utilities, the Iowa Association of Electric Co-ops, and the Iowa Utility Board in court on an issue that's critically important to them and won. Basically, it's Point Solar against the Iowa utility universe. The issue is third-party power purchase agreements, which 5 years ago I never would have had any idea what that meant, but I now know quite a bit about. So I'm going to couch what I know. I'm not a solar policy expert like Howard. I'm a solar developer. I'm a climate change believer and activist. So that's kind of where I'm coming from. I'm a businessman. So my remarks are going to pertain to the lead up to the pending Iowa Supreme Court case over third-party power purchase agreements, and I'm going to try and explain why this is so important to us. In the fall of 2010, I started Point Solar with my master electrician brother-in-law. I was a retired healthcare executive trying to figure out what the next thing in my life was. And solar photovoltaics was something that interested me. It was something that barely existed in the state of Iowa, and I saw a real market opportunity for it. So that's the reason why I got into this game. In the fall of 2010, I got reintroduced to Howard and ELPC. Howard and I, when we went to high school, I wouldn't characterize ourselves as pals. We were high school classmates, but we're pals now. I just wish I had the mental tools that he has to work with. So one of the first presentations that I went to at ELPC, the speaker was Julie Blunden, who was one of the top executives with SunPower. And this is a smart gal, obviously. She was talking about the Commonwealth Edison 10 megawatt solar field that they built on the Pullman?
West Pullman.
The West Pullman Superfund site on the south side of Chicago. And in hearing her speak to that, this was one of the best ideas I had ever heard of. On these Superfund sites, they can't be sold, they can't be developed, you can't do anything with them. Nothing but couldn'ts on Superfund sites. But you can build a solar field on a Superfund site. So I was just incensed with the concept of doing something like that because it's really not being done very much anywhere. So I brought that concept to the city leaders of Dubuque, Iowa, where my business is, and selected a site. Strangely, it was right next to the Alliant Energy coal-fired power plant on the riverside. I thought, why couldn't we put up we had about 6 acres to work with. Why couldn't we put up a megawatt solar field, pipe the energy right into this big substation, which is right across the street, get a credit for the energy for the city, they can use it however they use it. What a great idea. How naive could I be to think that I could ever work a deal like this with Alliant Energy, why they would ever agree to anything like this. So I started romancing the city leaders in Dubuque and elsewhere about solar projects. I still hope someday I can pull off turning a brown field into a bright field because that is just a great idea. In December of 2010, I had a meeting with regional executive of Alliant Energy to talk about solar projects because obviously my brownfield dream wasn't going to happen. And she said, find a building that has a great big roof and put a solar array on it and we'll be fine with that. We had talked about the need that this project had to be financed with a power purchase agreement because we're talking about a city building. They can't use the tax credits. So this was a discussion point. She really didn't react adversely to the concept of doing a power purchase agreement. After all, utilities do thousands of them. Every wind turbine is a power purchase agreement. So we went ahead, negotiated a deal with the city to put a 203 kilowatt solar array on a municipal operations building. Went through city council approval. I got Dubuque Bank and Trust to finance this project. Actually, they're not financing the project. They were the equity in this project because they would monetize the tax credits. Their law firm, which was a major international law firm that's done thousands of power purchase agreements, did the documents for this deal, including the power purchase agreement. Nobody at this law firm that worked on this matter had any idea that power purchase agreements were illegal. Pretty strong word, illegal. So we started the project midsummer 2010, and things were going really well. We complied with all of Alliant Energy's interconnection standards, did everything they asked us to do. We were very public about this being financed through a power purchase agreement. So everything was in place. It was going to be the largest PV array in the state at the time. We knew that wouldn't last long. And we thought this was going to be a smashing success and a template for thousands of other solar projects. So before I go any further, let me briefly explain how and why a power purchase agreement works. If you're a municipality, you can't use renewable energy tax credits because you're a non-taxable entity. So you have to have a third party, which in many cases is an investor or a bank, invest in the project. They take the tax credits, they take the depreciation, and they reduce the capital cost of the project by 60% or so, 55, 60%. So if it's a $100,000 project at retail, it's really a $40,000 project after incentives. The municipality agrees to buy all the project from the solar array or the wind turbine, and whatever energy is produced is sold through the power purchase agreement, usually at the price of grid power, maybe a little bit more, and then the avoided utility cost is what pays for the solar array. So this works very well in many, many states. Hadn't really been tried by non-utility players in Iowa, and that's what I did. So obviously, paying for these arrays with the avoided utility cost, utilities don't really like that. It really affects their business model. So when we were about 60% done with this project, and I had hundreds of thousands of dollars invested, most of which I borrowed from the bank before we flipped over the equity in the array. Got a call from an Alliant Energy official who talked to the city manager and said the project we were doing was illegal and must be stopped. Obviously, this was shocking news for me and the city and the bank, but really mostly me. We had a lot of capital deployed, and the project was now hanging there in limbo. So we immediately scheduled a conference call with Alliant Energy, their in-house lawyer, the renewable energy point person. Talk a little bit more about that later. My attorney, somebody from the city, about finding a way forward on this project because it just couldn't sit there half-built. Even Alliant Energy knew that.
I asked the question, you said that these purchase agreements had been done, routinely, hundreds of them, so.
Thousands of them.
All right, thousands, but they did not involve a third party, is that correct?
No, they often do. The distinction is, well, really the distinction is in Iowa, and I'm going to get more heavily into that as I do my discussion. But the utilities use power purchase agreements all the time, where they're getting the heartburn over it as somebody else is doing it. That's not a utility. So Alliant Energy said we could go forward if we structured it as a lease, an equipment lease, like we were leasing a car, not selling energy. And we had to do that. We got city council approval, finished the project, and the array has been producing flawlessly for the past 2.5 years. So while this project was completed, I was really chafed over how I was treated in this whole thing because they just attempted to run over me. I'm a small businessman in Dubuque, Iowa, a solar developer. They're a utility. I couldn't find anywhere in my reading where power purchase agreements were illegal. Basically, the position that they're taking is that if you produce energy in any form, that makes you a public utility. And being a public utility, if you sell power, kind of a circular reference here, you're invading their exclusive service territory law. Understand, I don't buy that argument, and neither have any of the environmental legal scholars that I've talked to buy that argument. Understand this: distributed behind the meter energy generation from solar or wind to a utility looks exactly like energy efficiency measures. To a utility, it looks exactly like energy efficient lighting, appliances, or even just turning your thermostat down. So, as part of my solar advocacy, I'm a founding board member of ISETA, the Iowa Solar Energy Trade Association, with Tim and Warren up there. And coincidentally, the following Saturday, we were having a board meeting in Cedar Rapids. And you guys, I'm sure, remember this quite well. I was a little bit agitated over this. And we talked about it. And during that meeting, Warren said, I've got somebody that I want you to talk to about this. And he made a phone call to an energy consultant that his REC uses. And he introduced me. I took the phone. We agreed to talk on my drive back to Dubuque from Cedar Rapids. So I emailed the utility's legal position that they tried to bulldoze me with to him. And once I got on the road, I called this former utility board member, and he was a little bit animated when we connected on the phone. The utility regulations that Alliant Energy was using to support their position that I'm a public utility, basically he said, these are utility regulations that he wrote when he was a board commissioner. He wrote these utility regulations. He understood the intent of these utility regulations, and Alliant Energy is using these to support positions that have nothing to do with the intent of the regulations. So in case anyone is wondering who this former Iowa utility board member is, it's Bob Latham. I don't know well. I've really only talked to him this one time. I asked Bob if he knew of a lawyer who could competently represent me in this matter before the Iowa Utility Board, and he recommended a lawyer named Phil Stoffregan in Des Moines. He's with the law firm of Brown Winnick. Phil's not the most exciting guy on the planet. After all, he is a utility lawyer. But he's the go-to guy for this type of stuff. So he did a conflict check on me, and I retained him as my lawyer in this matter. Shortly before I retained Phil, I was introduced to Brad Klein, a lawyer with ELPC in Chicago. Brad reached the same conclusion about what the position Alliant Energy was taking is just not correct, and he agreed to do a legal brief, not just for me, but for the issue. Anybody could obtain that legal brief, which in many respects is the underpinning of our legal strategy, of our legal argument that's now before the Iowa Supreme Court. This is a big deal. Since the power purchase agreement issue in Iowa was uncharted territory, at least my end of it, we had to decide what was our legal strategy going to be. So, what are your choices? We could have sued Alliant Energy in court. Well, how many millions would that have cost in legal fees? How many years, if not decades, would it take to come to trial with all the discovery and everything that has to take place in that type of a matter? That wasn't a great idea, but he came up with a great idea. Let's go to the Iowa Utility Board, give them the fact set of what happened, and ask them to issue a declaratory order that Eagle Point Solar is not a utility, public utility. I mean, think of that. It's not. Alliant Energy's position were true, there would be 3 public utilities in the state. Alliant Energy, Mid-America Energy, and Eagle Point Solar of Dubuque, Iowa. We are now the 3 public utilities in the state. That's their argument. That is their argument. So we drafted this petition for a declaratory order. Our position was based on clear Iowa statute and legal precedent. One of our main legal precedents was a 62-year-old Iowa Supreme Court case, which to my knowledge has never been challenged, which is directly on point. It's the Northern Gas case, and it specifies under Iowa law, and it's been used elsewhere, I think it was used in the Solar City case, what constitutes a public utility. There are criteria that you have to meet. It doesn't matter if you're an electric utility, a gas utility, a water utility, a telecom utility. It's what constitutes a public utility, meaning selling to the public. Is putting a solar array on a municipal building selling to the public? We didn't think so. So we drafted our petition. We filed it on January 11th, 2012 to kick this matter into high gear. Not to disclose too much attorney-client privilege stuff, but about a day or two after we filed this, I got a 5-word email from Phil saying, Pandora's box is now open. So you should see who came out for and against this. I'll start with the 4. There are really 2 constituencies in this matter. I kind of call them the green constituency and the black constituency, black coal. On my side, the green interveners were ELPC. They were in this from the start. Brad Klein, Josh Mandelbaum, Howard, of course, Steve Falk. And they lined up this group called the Solar Coalition. And tell you what the implications of this matter are. You just have to look at who's interested in it. Well, the Solar Coalition consists of ELPC, ISETA, our trade association, Renew, anybody heard of these guys? IEC, Iowa Environmental Council, Nathaniel Baer, Winneshiek Energy District. That was pretty much the Iowa representation, which is significant in this matter. But they also brought in some national players into this. Interstate Renewable Energy Council, IREC. Solar City Corporation, the largest solar installation firm in the world. SEIA, Solar Energy Industry Association, Sunrun, Suntech America, and Point Solar Initiative. They were interveners on my side supporting my position in this. Also on our side was the Office of Consumer Advocate, which was in direct opposition to the position that the Iowa Utility Board ultimately took. Lining up against me was the black constituency, consisting of Alliant Energy, Mid-America Energy, the Iowa Association of Municipal Utilities, and the Iowa Association of Electric Co-ops. So again, this was Eagle Point Solar and my 12 or 13 employees against the Iowa utility universe. All the parties filed their briefs and on February 25th we had a hearing in front of the Iowa Utility Board. Again, my side I thought present reasoned legal as well as public policy arguments. The utility side of the case came up with this parade of horribles that are going to happen to the world if solar becomes prevalent in the state. Our rates are going to have to go up. We're not going to be able to maintain our utility grid. We're not going to be able to put fuel in our trucks. All the terrible things that were going to happen if, well, I guess we don't have Howard's grid up there anymore, if that renewable slice expands and the coal slice contracts. So that was their position. Nothing to do with the environment, nothing to do with the jobs created, nothing to do with our energy dollars when we buy coal energy and it's really hot out in the summer. sending economic dollars out of the region and out to Ohio and New Jersey or wherever they buy their peak power from. On April 12, 2012, the Iowa Utility Board issued its declaratory ruling, and they concluded under the fact set presented that Eagle Point Solar was indeed a public utility. While we were disappointed but not shocked, we had strategized that this was going to happen basically because the Iowa Utility Board is no longer a regulatory body, it's a political body. So either way, win or lose, this was going to appeal. So that's what we did. This really was a good strategy because even though we lost this part of the strategy, I didn't spend millions of dollars and 8 years trying to sue Alliant Energy over this. We got there in 9 months. We filed our appeal on May 14th, 2012. Same type of deal as the proceeding with the Iowa Utility Board. Armies of utility lawyers presenting all these horrible things that are going to happen to the world if solar becomes prevalent and third-party power purchase agreements become legal. It's just basically the same thing. One thing that I'll note is the Office of Consumer Advocate, which normally sticks their nose in these matters representing consumers, was not done by a staff attorney. It was done by Mark Schuling, the consumer advocate himself. He took this on and did this personally. I don't know how many matters that he handles personally, but he did this one. On April 8th, Judge Schemmel released her ruling on our appeal. She completely reversed the IUB declaratory order, and from our perspective, this was a complete victory. Because right now, power purchase agreements are legal in the state of Iowa. That's not the whole story now because it's now on appeal with the Iowa Supreme Court, so that could reverse itself again. We don't think it will, but we viewed that as a complete victory. Phil told me that normally what a judge would do is send it back to the Iowa Utility Board and they would reconsider it and hopefully come up with a different answer. That didn't happen here. She ruled on it. She just ruled on it. Didn't send it back to the Iowa Utility Board. We thought that that was significant. So, as you'd expect, the utility universe didn't think much of this decision. I'll give you a couple of examples. On April 13th, sorry, I'm going to have to pick this up and read it because I'm quoting. The Dubuque Telegraph-Herald wrote a piece on the story, and they've been following this for years. In that story, the Alliant spokesman said, "We're still trying to figure out what it means. What we know is this order only applies to that one installation on that one building in Dubuque. It's not a broad order or policy change overall. It only applies in this one instance." Really? Just one building. It's just this one building. No other buildings, no other schools, no other fields in any city in the 99 counties in Iowa. This is just this one building. This is what they really believe. If that's what they believe, they're the only ones that believe it. We just don't see it that way. On May 2nd, KWWL-TV did a story on the case. And in that story, the same Alliant spokesman put a new spin on this, and this is really left the reservation on this one. Quote, "A city or a church, they do not pay taxes, so therefore the cost of the system is sticker price, because they can't qualify for the tax benefits. But when a third party comes in there, then they're able to qualify for the tax benefit and make the system cost easier for them to afford. Do taxpayers want non-tax-paying entities to get these benefits?" Wow. They're now carrying this so that they don't think that municipalities should be allowed to have renewable energy. They should pay retail. They should pay sticker price. solar array costs $100,000, and with a third-party power purchase agreement, it's effectively $40,000. The city has to pay $100,000 because they're not taxpayers, they're not entitled to any of it. I just wonder if this Alliance spokesman considered how the mayors, city managers, university presidents would take that comment. So why is this case so important? Why has this matter been published in local, regional, national publications? Why am I here speaking to you today? Why did I spend 90 minutes on the roof of the Dubuque Maintenance Operations Center, which is the project that spurred all this turmoil, on Wednesday with a photographer from the Wall Street Journal? There will be a cover story in the Wall Street Journal probably Monday, maybe Tuesday, on this court fight. This is now starting to receive national attention. Why is this so important? Why are there 20, 25 utility lawyers at every one of these hearings trying to block renewable energy in the state of Iowa, including the Alliant Energy Renewable Point person? I don't really want to single her out, but maybe I do. She should be on the other side of this if she's a renewable energy point person. The answer is simple. This is about economics and power. Without the ability to do third-party power purchase agreements, these projects just aren't feasible. They're not feasible. Tim, how many municipal projects have been done in the state besides mine?
Maybe 3 or 4.
I mean, it's just not happening. A leasing structure doesn't work. The IRS looks to the tax nature of the entity at the end of the food chain. That doesn't work. The power purchase agreement, if you go to the Department of Energy's website, that's what they recommend in terms of structuring these deals. So without third-party power purchase agreements, Tim and I and others have no way of structuring these deals for municipalities, universities, religious institutions, any non-taxable entity. That's what's at stake here. This stuff, these solar arrays, should be everywhere. We are now at grid parity. I can sell energy to these municipalities through a power purchase agreement that's right there with the cost of grid power. These municipalities with a power purchase agreement, they don't have to make a capital expenditure. It's basically put on their roofs turnkey. All they have to do is pay for the power that they're buying anyway. It's a no-brainer except for one thing. We need a contractual structure that works, and that's the third-party power purchase agreement. So the utilities have decided as a group, Alliant, Mid-Am, the munis, the RECs, that this fight's not over. We're going to take it to the Iowa Supreme Court. I think what they're really doing is trying to push this inevitability off, maybe a year, maybe 18 months. But I don't think there's a sight line for a win there. I'm not a lawyer. I've talked to loads of environmental legal scholars. Basically what has to happen is they have to prove that Judge Schemmel made just a serious mistake in interpreting a law, a mistake in interpreting a law or statute. She didn't. So let me just say a few more comments. Banks want to make these deals. They want to do third-party power purchase agreements. Banks are drowning in cash. They can get good returns with virtually no underwriting risk in these deals. They want to do these deals. They're ready for them. Taxpayers, they want their municipalities to do these deals. They want solar on their rooftops. They want the economics to stay local. They don't want their power bills that they're paying, wind up paying for energy that's generated in Ohio or New Jersey. As I said, this matter is now before the Supreme Court. The utilities are doing this to protect their top line. They want to keep their feet on the brake to slow solar power development, and I'm fine with all this being in front of the Supreme this will really settle this matter, and this will have precedent in other states as well. They can't reintroduce all the purported bad things that they say happened in the Iowa Utility Board matter and in the appeal. Strictly, did the judge make a mistake? No new facts, theories, or witnesses. And there's one other factor. They're going to have me speaking in front of groups like this until this is settled. So the PR aspect of this is not going to be good for the utilities. One more thing that I want to say, that kind of got to get to the right place in my notes, because this is another quote. Susan Stewart, who's the attorney for Mid-America Energy in the appeal trial, made a jaw-dropping statement that really brings into focus why the utilities hate this so much. So, just so you know, I'm not making this up. If you want to look at the transcript, page 66, line 22, this is what she said. Quote, "It's clear from the interest in this case that participation by the solar interveners and others, if Eagle Point is successful there will be a boom in the proliferation of solar in the state." Let me say that again. It's clear from, this is Alliant Energy's lawyer in the appeal trial. It's clear from the interest in this case, the participation by the solar interveners and others, if Eagle Point is successful, there will be a boom in the proliferation of solar in the state. Wow. Couldn't have said it better myself. So Judge Schemmel on the bench, this is my opinion. This is not a new transcript. It wasn't videoed. She carefully listening to the case, but when Susan Stewart said that, she did one of these. She absorbed that remark. That was a significant thing for her to say. I guess she realized pretty quickly what she had said because she didn't have a whole lot to say after that, but this is from Mid-America's attorney. Phil, my lawyer, who I was right behind, he was up in front where the lawyers get to be, he turns around and whispers to me, "I can't believe she said that." That was quite a moment. So we won at the appeal level. Power purchase agreements are law in Iowa. It's possible her decision may be reversed. I think it's pretty unlikely. But that's where we are on this matter. It turned into a very significant matter. So let me conclude my discussion by giving you a few solar facts that Tim, Howard, everybody else has that are pretty fresh. Came out Thursday in a report by SIA and GTM Research about the growth of solar. And these are some pretty staggering numbers. Solar installs in the first quarter of 2013 were 723 megawatts, which accounted for 48% of the new electric capacity installed in the U.S. So you take all the coal plants, all the bio plants, all the everything, solar installs in the first quarter of this year were 48% of the new electrical capacity put online. What are we doing in Iowa? Next to nothing, barely measurable. I'm going to skip the part about residential and utility scale, but it was significant. Projected solar installs in the U.S., according to this report, are 4.4 gigawatts in 2013, growing to 9.2 gigawatts by 2016. If we don't get our act together now and create some legislative initiatives and policies to promote this technology, we're missing out. Again, we've attained grid parity with solar. I can develop these projects, deliver these projects turnkey, and all the utilities or universities and schools and churches have to do is pay for what they're buying anyway. So I thank you for your time. I'll be happy to answer any questions you have, and look forward to getting this resolved in front of the Supreme Court.
Okay, we're about half an hour pushback, so we've got 15, 20 minutes. Any questions?
Could the utilities push through legislation at the state level that would permanently fix that problem that they have?
Well, the answer is yes, they probably could, but the Democrats have control of the Senate. Pam Yocum, my senator from Dubuque, is the Senate president. I don't really see that initiative getting anywhere in the Senate. The House is Republican controlled right now. Makes it difficult to get solar legislation or distributed renewable energy legislation, I guess I should say, through the House. I don't think that Governor Branstad would be a proponent of anything like that. He's the renewable energy. I think his legacy at the end of the day, at the end of his career, is as the renewable energy governor. His renewable portfolio standard in the 80s, I think, was 110 megawatts, 105 megawatts. We have 10,000 megawatts of wind power. He was the genesis of all that. So I don't see the utilities being able to push forward any legislative initiatives that are going to stop this.
Thank you, Barry. I'm Jim Martin Schramm from Luther College, and I want to thank you for your leadership and Eagle Point's willingness to reach into their pockets to take this case forward. It's not an insignificant financial undertaking on your part. We know this because we started down that road with our wind project. We looked at our LLC selling power to Luther College. I got slammed down pretty hard. And it was pretty clear that if that was going to change, we would have to become antagonistic with Alliant, and that wasn't it just wasn't where we were going to go. And so when we were offered the opportunity to join on as interveners for your third-party PPA case, we were again worried about our relationship with Alliant and chose not to intervene. So just understand that I think there are a lot of customers out there that feel intimidated by their utility. And anyway, I just want to say thank you to you for your leadership.
Thank you.
There are two questions though that I do want to pose. One is, now that the court has issued its ruling, have you signed up any parties for third-party PPAs, and what would be the status of those? Let's say you inked a deal with Luther, and we went ahead and it was installed, it was all installed, and the ink was dry on the contracts before the Supreme Court ruled. What would be the status of a third-party PPA in this current legal situation?
So that's a great question. The answer for me is I'm just not pursuing these deals. While the banks, Dubuque Bank and Trust in particular, but the other bank in town and other banks throughout Iowa and elsewhere, they want to do these deals. They're underwriting risk for the city of Dubuque. Is the city of Dubuque going to pay their energy bill? That's almost immeasurably low. But as long as there's a risk of this thing being overturned by the Supreme Court, I really can't get a bank pregnant with one of these third-party power purchase agreements with the risk that something could happen in a couple of years and leave this in contractual limbo. So I'm not pursuing these deals right now.
So the second question is sort of similar to Tom's question. I'm a little worried about erosion on the net metering provision in Iowa. And I don't know is that in fact what we have is a net metering law. I think what we have is a provision that's part of the IUB. And so one way to throttle these third-party PPAs would be to take or to reduce the cap from 500 kW to 200 kW or 50 kW, which some states in the surrounding area have. And have you heard anything about that? And any of the rest of you that know anything about this, am I wrong? I mean, I guess I don't know whether we have a law or whether we just have a
qualify myself and disqualify myself because I'm not really a policy expert. What I've run into with net metering and Alliant Energy in particular is they are taking the position that any customer that has a demand component to their bill, which is virtually every commercial customer, is not eligible to net meter. So,
Even if you net meter, you'd just be netting the energy only.
Yeah. Hey, Barry,
The economics of net metering on a commercial customer will not pay for the system.
Josh, are you here somewhere?
Here. Josh Mandelbaum, Environmental Law and Policy Center attorney in Des Moines. Jim, let Josh is working on it, let him address it.
Well, a couple pieces. To answer your question, we have net metering rules in Iowa, and that requires a rulemaking process that the Utilities Board would conduct in their processes that it's not a simple process that could be overturned quickly or easily. There is currently nothing in the pipeline to limit net metering in that way. That doesn't mean that it's not something that the utilities are considering or a strategy that might come up in the future, but we would have plenty of advance warning and plenty of opportunity to have input into those rules and to prevent that type of change.
I think you're seeing that kind of on a national level. California, that's kind of in debate now.
Right.
Since California has really expensive energy, they're in tiers. So some of their top tiers with solar offsets is, you know, like 23, 25, 35 cents. So it really takes a bite out of the utilities revenue stream. So they're fighting net metering on some of these high expensive territories. But in Iowa right now, we haven't seen that yet, but we feel that that might be something, since it's starting in other parts of the more mature markets, you might see that, like a solar tariff, so to speak. So.
Obviously, we've spent a lot of time on the renewable electricity side here, but Howard, with you here, I just want to take an opportunity just to ask you about the status from your perspective on the regional rail redevelopment efforts and what that would mean for our economy. Obviously, that's been a big deal in the Quad Cities in eastern Iowa, and I'd just like to get your thoughts on it, since you've sort of been the architect of the regional redevelopment of rail throughout the upper Midwest.
Thanks, Robin. That wasn't a setup. I'm glad to address it. All right. The rail system in the Midwest, I sometimes describe historically as being somewhat better than Burma, not quite as good as India. You know, anybody who's traveled on modern higher speed rail in Europe or Asia, or even on the East Coast of the US says, why in the world can't we have this here? What we're talking about is modern new rail cars running on upgraded existing track with modern signals that move people from place to place and do ways that improve mobility, reduce pollution, create jobs, and pull together the regional economy. Modern new rail cars, upgraded existing track, you know, at speeds going up to about 110 miles an hour.
Renewable energy.
If we can power them with renewables, let's do it. All right. So here's what's going on. President of the United States, Barack Obama, says his #1 transportation priority is high-speed rail in the United States. You think about that, it's remarkable. The #1 priority of the president of our country is developing modern rail that's good for jobs, good for economic growth, and good for the environment. Trains move less than cars and airplanes on a per passenger basis. It provides people access to jobs and family. It enables people to get from place to place, to their jobs, to other places that they're working. So what's happening? In the first term, there's about $12 billion put into higher speed rail. Governor Kasich of Ohio said, we don't want it. Republican Governor Gary Snyder Rick Snyder of Michigan, said, we'll take it. Republican governor. Michigan now owns all the track between the Indiana border and almost Detroit. There are modern new rail cars and new locomotives being built that involve businesses here in the Midwest in the supply chain making the parts. And Governor Snyder has seen a tremendous advantage of being able to connect people and jobs between Niles, Michigan, and Kalamazoo, and Battle Creek, and Ann Arbor, and Dearborn, and Detroit. Because it's good for jobs, it's good for mobility, it's good for economic growth, and it's good for the environment. Governor Quinn in Illinois, St. Louis to Chicago. Within 2.5 years, there will be modern, spanking new rail cars with new locomotives running between Chicago and St. Louis and going up to Milwaukee. Polluting less, better mobility, enable people to get around and get there faster. Makes a lot of sense. Governor Branstad and Iowa are sort of the outlier. Haven't quite said no, haven't quite said yes. Governor Quinn in Illinois is moving higher speed rail to go from Chicago to the Quad Cities. The environmental impact statements are being done and the public hearings are being done on the Quad Cities, to Iowa City, to Des Moines, to Council Bluffs, and to Omaha. There's a pretty convoluted legislative process that Senator Hogan described on how the money that State Department of Transportation wanted to move forward on high-speed rail didn't get approved, but maybe will get approved. Just think about it for a minute from Iowa's perspective. There's going to be more money coming from Washington, from a president who said this is his #1 priority. Republican governors and Democratic governors in the Midwest and nationally are moving forward. Does Iowa want to seize this opportunity to develop a transportation system that enables people to move across the state through the major central cities in the state, or let that money go somewhere else? What's the upshot of Governor Kasich having said no to the federal high-speed rail money from Ohio? It went to Michigan. Michigan's doing it. Anybody here go to either Michigan or Ohio State for college? All right, I went to Michigan, okay? You know, on Fridays, people wear t-shirts that say, oh, how I hate Ohio State. All right? Governor Snyder has 3 degrees from the University of Michigan, okay? He's played this beautifully within the context of Michigan politics to say that we're taking Ohio State's money and using it for modern rail in Michigan, creating jobs, pulling together the economy, and reducing the pollution and increasing mobility. You think that's a winner or a loser? That's a winner, okay?
Competition again.
Time for Iowa to step up. This is an opportunity, as Rob Hogue has said, time to seize it and move forward. There's a real simple what if not what. It's not like it's not going to happen. It's just going to happen somewhere else. That's a dumb result for Iowa. Let's work together with others, including the Greater Des Moines Partnership, the Chamber of Commerce, to make this happen. I mean, just think about this. Barry described rightly, you know, here are the utilities, business. Here's the emerging solar businesses and the environmental groups. In Iowa, we are working like this together with the Chambers of Commerce, the Greater Des Moines Partnership, Quad Cities Chamber of Commerce, Iowa City, Des Moines. Let's make this happen and get it done. This is something for everyone in this room who's concerned about climate change solutions and better transportation and job creation in Iowa. Let's get this done.